Welcome to Rock Center Shorts. I'm Kristen Savell, Co-Executive Director at the Rock Center for Corporate Governance at Stanford. My guest today is Lenin Lopez, Senior Vice President and Corporate Securities Attorney at Woodruff Sawyer. Lenin provides legal counsel to public company boards and executive management, helping them to navigate a range of legal and business matters, including corporate governance, securities law compliance, capital market transactions, executive compensation, and other general corporate matters. Welcome, Lenin.
Thanks.
Today, we're going to talk about officer exculpation under Delaware law. And this is a relatively new development. So, Lenin, can you give us a refresher on how this came about?
Yeah, no, it's a great question. I think it's important to go back a little bit in time to provide some context here. And so we'd have to go back to the mid-'80s. There's a case involving a cash-out merger of TransUnion. The board in that case negotiated and closed the deal for a sizable premium, but a fiduciary duty suit was still brought against them. The argument there was effectively that the directors failed or breached their duty of care. And so the argument was that they didn't review all the documentation related to the adequacy of the purchase price. They didn't bring in outside consultants to determine what was a correct value or an appropriate value for the purchase price. So fast forward, and the case ended up settling for about $23.5 million. And what's interesting here is that the company's D&O insurance policy was for only 10, which conceivably would mean that the other 13.5 would have to come out of the directors' pockets. Now, undoubtedly, right, this created somewhat of a chilling effect in terms of director recruitment around the time, and also made the D&O insurance a little bit more, or the market a bit more challenging. So in response, Delaware came in with their cape and adopted a new law to permit companies through their certificate of incorporation to exonerate directors from personal liability for these types of cases. And so what now you have is these director exculpation provisions, pretty commonplace in Delaware corporation certificates of incorporation. And it's resulted in plaintiffs effectively being discouraged from bringing these suits because they can typically be dismissed on a motion pretty quickly. So then now the plaintiff's bar has realized that there's a gap, right? So there isn't a similar protection for officers, which means that the plaintiff's bar has brought these cases typically in the context of M&A litigation with the goal of raising the stakes in terms of trying to increase settlement values, and it's worked. So looking to avoid the same issue that we ran into in the mid-'80s, Delaware came in around August of last year, or we're 2024, August of 2022, to extend the same protection to officers that directors currently have.
Great. That's important background to understand. Under the amendment, which officers are eligible for exculpation?
So short answer, your executive officers, but the more complete answer lies in a statute under Delaware corporate law. It's by title. So it's your CEO, CFO, president, chief operating officer, chief legal officer, controller, treasurer, chief accounting officer, and then for public companies, those individuals that are listed as your named executive officers effectively in your comp table, think proxy statement. And there's one last piece, which I would say is probably best reserved for your corporate secretary to sort of wade through, but it's individuals that have consented to being identified as an officer for purposes of accepting service of process.
And what does that mean? Can you unpack that last language a little bit, consenting to be identified as an officer for purposes of accepting service of process?
Yeah, no, it's a good question. Yeah, so having sat in that seat for a bit, there are a number of annual types of filings that you file with the Delaware state. One of them is your annual report. You typically list a number of officers in there, and they may not all be the same ones, or typically aren't the same ones that are listed in that statute that I referenced. So corporate secretary would be in there. So I would say typically corporate secretary may fall under this. Your head of tax may be another one for certain types of filings that they would be in a position to accept service of process. So
great. All right, so the 2022 amendment to the Delaware General Corporation Law doesn't permit companies to exculpate officers from all liability So can you tell us about some of the limitations of the amendment?
Yeah, no, it's a good question, and I think, at first blush, some people think that, look, this is a free pass, right? You can so throw caution to the wind and do what you want. It's not the case. It only eliminates personal liability in the cases of duty of care claims, and then brought directly by stockholders. So it wouldn't protect officers from being personally liable for, let's say, like breaches of duty of loyalty, good faith, intentional misconduct, self-dealing, or any claims brought derivatively or by the board, for example.
Okay, Lenin, so how significant is this amendment? And I ask that because, as you noted, the amendment doesn't permit exculpation from liability for breaches of the duty of loyalty. And just last year, in the McDonald's Corporation stockholder derivative litigation, the Delaware Court of Chancery for the first time explicitly acknowledged that officers of a Delaware corporation owe a duty of oversight. That duty of oversight is part of the duty of loyalty. So officers still remain vulnerable to oversight claims, even with an exculpation provision in place. So is this a sea change, or is it something less dramatic?
So I think it's something. I think it's something in between, right? Like, so not a very clear answer, but I think what the McDonald's case did, right, is it confirmed or at least clarified what many of us corporate nerds, and I think you're sort of in that boat too, sort of thought to be the case, which is that, Delaware corporations, at least for officers, their fiduciary duties are comparable to some degree, right, to directors. So you're right. I mean, even if we were to assume that McDonald's had an officer exculpation provision in place, it wouldn't have protected that officer from the case that was brought against him. What I will say, though, is that that case, I think, caught the eyes and the attention of a number of people, right? After that decision came down, and it was, there was thrown out a technicality, so there's that piece, but it's still, there's still a lot there for people to pull from, and plaintiffs' attorneys. So I think what we'll see potentially in the future is more cases brought against officers for breaching their fiduciary duties. And in the case of duty of care cases, like I said earlier, these have typically come up more so in the M&A context, but I could see these coming up also in the context of disclosure. So potentially officers allegedly, right, not having reviewed all documentation tied to, potentially securities filings, things along those lines. So in that case, I still think it's an important belt and suspenders in terms of providing a good protection or minimizing your risk profile.
Right. And what steps do companies need to take to extend exculpation to corporate officers?
So in order to be able to benefit from this actually needs to be baked into your certificate of incorporation. That requires stockholder approval. For private companies, this should be relatively easy. It's just a matter of getting the board to approve this and putting it up for stockholder vote. And since the universe for private company stockholders for companies is relatively small, it shouldn't be that heavy of a lift. In terms of public companies, it gets a bit more involved, right? I mean, you end up having to put this to a stockholder vote, which would then need to go included in a proxy statement. And for those of us who have gone through that process for a non-routine matter, it's a matter of getting the vote out, right? And making sure that your institutional stockholders, proxy advisory firms, you name it, are on board so you can get the vote.
And how does that process work for companies with a multi-class stock structure?
So it's clear now. Two companies out of the gate. So I mentioned that this sort of all became a reality for an option for companies in August of 22. Fox and Snap were two of the companies that came out, right? That's in that fall to put this to stockholder vote. They are both multi-class structured companies. They ended up getting approval, right? So they both got put these up for vote. They both got them approved. But then plaintiff stockholders ended up coming out, sort of falling from the ceiling tiles, and brought actions against them. The argument was effectively that the companies put the proposals up for vote together as a single class. So rather than splitting up, we're going to ask for approval from our Class A or Class B or Class C, for example. They bunched them all together and got approval that way. The lawsuit created a significant amount of angst, I think, for other companies generally, but then more so for multi-class companies who were trying to figure out how this was all going to play out. Fast forward to now, and that's effectively been resolved. Delaware court basically came in and didn't second guess the way that Fox or Snap structured it. So moral of the story is that if you are a multi-class structured company, if you follow suit in the ways, not lawsuit, but if you follow the way that Fox or Snap structured it, you should be in good company.
Great. So some benefit for those companies that opted to wait.
Yeah, no, exactly. Yeah, no, and the benefit too, right, is that those companies that waited get to benefit from all the legal spend that Fox and Snap ended up expending. So,
right. Well, let's talk a little bit about what we saw in the 2023 proxy season, because we have 1 year behind us now. Companies are undoubtedly looking at those results, evaluating them, and trying to figure out how to proceed in the coming years. So what did we learn in 2023 with respect to officer exculpation proposals?
So as a general matter, it was all, stockholders were supportive. If companies put them up for a vote, they typically got passed. From a statistics perspective, Weil published some statistics shortly after last year's proxy season. I can give you some numbers here. So 279 public companies put these up for a vote. Around 80% of those were approved. And in terms of thinking about S&P 500 companies, of those that put them up for vote and approval, figure was around 30. So around 30 that in the S&P 500. So.
Okay, great. That's 30% of the S&P 500 that put
30,
a proposal.
30 numbers, not 30%, but 30
Got
companies.
it. I was
so
going to
small,
say,
but
that seems actually quite high.
No,
so do we
no,
know
30.
what percentage of Delaware companies have adopted officer exculpation provisions to date?
It's I don't have the particular numbers, but I generally, because I've been asked the same question, right? From clients and from friends who are still in house. The answer I generally say is, look, the companies that did decide to go out like the first time, which is last year, they were all generally met with an approval. And I will say the caveat there, or not even the caveat, but what's interesting as well is that in terms of proxy advisory services, or proxy advisory firms, so we're thinking ISS, Glass Lewis, it wasn't, at least from the Glass Lewis side, they typically recommended a vote against, right? So take away from that, stockholders, at least in terms of how the companies have teed it up in their proxy statement, understand, the value of this and the purpose.
What are the recommendations from Glass Lewis and ISS for the 2024 year?
So they're generally the same. So last year, ISS basically is, the way I explain it is they come at it from different perspectives, but it's generally a case-by-case sort of assessment. They want you to describe why you are putting up for a vote, why the company views it as important. But ISS will come at it from, as the way I think of it, is ISS will come at it we will recommend for unless you give us a reason not to. And then Glass Lewis is, we're going to recommend a vote against unless you give us a reason to vote for. But Glass Lewis has generally sided on we're not going to recommend a vote for. But that's sort of it. It hasn't changed. And again, I still think it's a good point, these proxy advisory firms, that their recommendations as something to include in the calculus for all that. But just the way the numbers turned out last year, it really didn't have an impact or move the needle negatively, right?
Sounds like it.
Yeah.
So what do we know about the officer exculpation proposals that failed last year? If we had around 80% pass, that still means, around 20% did not pass.
Yeah, so it's interesting. I mean, I think the reason that some of these didn't pass, or at least when we're sort of looking back at it, was in terms of meeting the required voting standard. So in order to change or amend your certificate of incorporation, generally it's a majority of your outstanding stock entitled to vote. In some cases, a supermajority, so thinking 80% or more. And so it's a matter of basically, I don't know, I remember growing up, it's like rock the vote, right? It's making sure that enough of your investors come out and vote. And there was an interesting stat that Sullivan Cromwell put out, and they said that those companies that failed the supermajority vote, if they had a supermajority vote requirement, if they would have had a majority standard, those proposals would have passed. So again, moral of the story here is that for those companies that failed, my sense is, based on what I've sort of been tracking, is that it was a matter of not getting enough votes, which then sort of begs the question, all right, what could you have done better? Or if you're a company that's going out and thinking, okay, we want to put this up for a vote, we don't want to run into that issue that we failed because we didn't get enough people to come out, or, you know, institutional investors. You know, work with your proxy advisory firms, have conversations, right, leading up to the vote with your large institutional investors, and keep count, right? I mean, it's sort of, there's a path to get there. It's just a matter of putting in the legwork, I suppose.
Right. Well, as we talked about, a number of companies took a wait and see approach last year. For those, what are some questions that boards should be asking, or steps that they should be taking now as they consider whether to put an officer exculpation provision to a shareholder vote this year?
So I think, you know, a lot of it is just getting up to speed. So having an understanding of what we sort of went through, is a little of the background. I think that's important for directors to be made aware of, right? They may, you know, articles don't typically get into that much detail around, all right, it's this case, and it was this settlement, they didn't have this, the D&O insurance wasn't likely there to help protect those directors in that cases. So from that perspective, I think it's important to have a little bit of the history. The other is, you know, do officers really care about this? Asking those types of questions. Will this help us in terms of recruitment or retention? I think as more companies adopt officer exculpation, it's going to be sort of table stakes, similar to how it's one of these things now where it's commonplace in terms of a certificate of incorporation for directors. I think officers will start asking the question. But as a general matter, I would generally view officer exculpation in the same light, or as a way to reduce frivolous litigation. So I think federal choice of forum provisions, and I'm sure there's others out there, where companies now view these as, look, we need to include this in here to reduce our potential litigation exposure. And again, it's a good backstop too, in terms of financial liability, which can be expensive, right? And it may not always be available in terms of like D&O insurance, for example. But those are the big ones.
Perfect. Thank you. So companies are identifying the rationale for adopting an officer exculpation provision in their proxy statement. I'm wondering if you can tell, by looking at 2023 data, which rationales garnered shareholder support and which did not?
Yeah, a good question. And I think, you know, after I looked at more than I'd like to admit to, at least proposals, they all sort of were in the same spirit. They made sure to explain that, look, it's officer exculpation, you know, it's not a free pass, it's very limited. The other piece is it's necessary, or at least in the company's view, it's necessary to adopt this for purposes of recruitment and retention perspectives, limit risk profile. And then one thing that, you know, was a focus too, was that it affords officers the same level of protection that is already afforded to directors. So along those lines, I think, you know, investors understood that this isn't something that is necessarily being put in place to put them in a worse off position, at least, you know, stockholders.
So are there certain types of companies that would most benefit from an officer exculpation provision? In other words, which companies should be rushing to add a charter amendment proposal to their 2024 proxy statement if they haven't done so already?
So my former life before D&O insurance brokerage was pharma and life science, and that's a volatile area, right? In terms of a lot of acquisition, a lot of M&A, and we're seeing that now in the market, right? So if you're small pharma, mid-sized pharma, big pharma is coming after and buying you up. That's a situation for those companies that could potentially be targets. I would strongly recommend considering putting these in this year if you're a public company. You may find yourself in an M&A situation, and as I mentioned before, plaintiffs' attorneys are leveraging these types of claims to extract a bit more in terms of potential settlement value. So those companies, right? So it doesn't have to be pharma. It could be you're just another company that as part of a strategic sort of evaluation of where you may be. M&A may be in the future. So I would be sure to focus on that. So
great. Is there ever a situation where it would be in a company's best interest not to extend exculpation to corporate officers?
Yeah, the one example that comes to mind is, if you are in the process of getting acquired and you have to put that acquisition up to a vote for stockholders, that proxy statement, that merger proxy statement, is probably not a situation you want to put Officer Exculpation up for a vote. It's not a good look, right? You're asking for approval for M&A deal, and on the other side, you're asking for stockholders not to hold them liable for duty of care. So that is one example. Another is, right, if the company is in the process of working through a controversial proposal within their proxy. It could be, even maybe a say on pay, a controversial say on pay year, right? Where you may not want to distract or create more issues. That may be another situation where you may want to consider holding off.
Good tips. All right, last question, because I'm sure many people are wondering, does an officer exculpation provision have any impact on D&O premiums?
I wish I could say it would lower them, but unlikely. What's more likely the case is that this is going to be a topic on future, renewal calls, or when you're looking to get insurance. While we haven't seen a significant ramp up in this coming up in underwriter renewal calls, it may factor into general risk profile. And for those companies that have adopted it, we are highlighting it on renewal calls to say, look, the company takes governance seriously, takes limiting or reducing sort of its risk profile seriously, and it's been received positively. I think what we'll see now in the future, in a year, maybe two, is that insurance underwriters will start asking, do you have it, right? Proactively, do you have it? Are you thinking about doing it, and why not?
Right. Well, thank you so much for joining me today, Lenin.
Happy to be here. Thanks.
Great. And thanks to all of you for watching. See you next time.